Imagine federal agents search your home. They find your legally registered gun locked in a safe. They find marijuana. You tell them the truth, you smoke to help you sleep. A few times a week. That honesty almost cost one American man 15 years of his life. Today, the Supreme Court just said that can never happen again. Here's what just changed in America. For decades, a federal law quietly stripped millions of Americans of their Second Amendment rights, not because they committed a violent crime, not because they hurt anyone, but simply because they used marijuana. Smoke weed, lose your guns. That was the law. On June 18, 2026, the Supreme Court struck it down, unanimously, 9-0. And the ripple effects of this decision touch somewhere between 43 and 62 million Americans. Stay with me, because by the end of this video, you'll know exactly what police can no longer do to you, what the law still allows, and what's coming next. Let's start with the guy at the center of this. Eli Daniel Hemani. Born in Texas. Dual U.S. and Pakistani citizen. For 3 years, the FBI had him under intensive surveillance, wiretaps, subpoenas, even monitoring his brother studying abroad in Iran. They suspected him of ties to radical foreign organizations. After 3 years of investigation, they found nothing. No terrorism. No espionage. No trafficking. What they did find when they searched his parents' Dallas area home in August 2022 was a legally registered Glock 19, locked inside a safe in a bedroom closet, and 60 grams of marijuana nearby. Hemani cooperated fully. He handed over the gun voluntarily, pointed out the marijuana himself, and sat down for an interview on the spot. When asked about his marijuana use, he told the truth. He smokes every other day to help him sleep. That honest answer became the entire basis of his federal prosecution. Under 18 U.S.C. Section 922, G3, a section of the Gun Control Act of 1968, it is a federal felony for any unlawful user of a controlled substance to possess a firearm. The charge carried up to 15 years in federal prison and a lifetime gun ban. The government used that same law, the exact same statute, to convict Hunter Biden in 2024 for owning a revolver while using crack cocaine. Biden was eventually pardoned. Hemani had no such safety net. He sat in federal detention for 6 months before trial. Not because he was violent. Not because he was dangerous. Because he smoked marijuana and owned a gun. But here's the real question, was the law that put him there even constitutional in the first place? To understand why Hemani won, you have to go back 4 years. In June 2022, the Supreme Court issued one of the most consequential Second Amendment rulings in American history, New York State Rifle and Pistol Association v. Bruen. Before Bruen, federal courts evaluated gun laws using interest balancing tests. Essentially, does this law serve an important government interest? If yes, it probably stands. Bruen threw that entire framework out. The new rule: if the Second Amendment's text protects a citizen's conduct, the government must prove that its modern firearm restriction has a direct historical equivalent from the time of the nation's founding. Not a similar spirit, a relevantly similar analog, same purpose. Same mechanism. This single ruling triggered a legal earthquake. Nearly 3,000 Second Amendment challenges were filed in federal courts after Bruen. About 88% of gun regulations survived, but a specific category of laws began collapsing almost immediately: status-based disarmament laws. Laws that strip your rights not because of something you did, but because of who you are. Section 922, G3, the marijuana user gun ban, was exactly that kind of law. The government's strategy to defend it? Point to founding-era laws targeting habitual drunkards, and that's where their argument fell apart. Because what exactly counted as a habitual drunkard in 1791, and does smoking marijuana every few days even come close? The government told the Supreme Court, look, the founders restricted gun rights for habitual drunkards. This is the same thing. Justice Gorsuch, writing for the court, dismantled that comparison piece by piece. A habitual drunkard under founding-era law wasn't someone who drank regularly. Early America had a robust drinking culture. Alcohol was everywhere. The legal threshold for habitual drunkard required severe cognitive impairment. Practically incapacitated. Unable to manage their own affairs. Mentally incompetent. And even then, those founding-era laws didn't disarm drunkards. They confined some to workhouses. They appointed guardians to manage their property. They required bonds for good behavior. None of them said, hand over your guns permanently. The government was trying to argue that a Texas man smoking weed to sleep a few nights a week is constitutionally equivalent to someone so destroyed by alcohol they can't function in society. The court said, not even close. But the Second Amendment problem was only half of it. There was a second, separate reason this law couldn't stand. Here's something remarkable. The federal statute that prosecuted Hemani never once defined what unlawful user actually means. Not once. Hemani's legal team, which included the ACLU and attorneys from CUNY School of Law, posed this question directly to the Supreme Court. Does smoking marijuana once a year make you an unlawful user? What about once every 6 months? Once every 2 weeks? Does the amount matter? Does the frequency matter? The statute says nothing. Federal courts across the country had reached completely different answers. Some circuits required a close connection between drug use and the time of gun possession. Others allowed prosecution based on a single positive drug test within the past year. The government's response was, don't worry. We only use this law against habitual users. The court's response. The word habitual does not appear anywhere in this statute. You cannot rewrite federal law from inside the executive branch. That violates the separation of powers. And here's the knockout punch. The companion clause of the same statute already bans people addicted to controlled substances from having guns. Addiction by definition requires habitual use. So if habitual user is the standard you're using for the unlawful user prong, you've just made the second clause completely redundant. The law was void for vagueness. It failed to give ordinary Americans fair notice of what conduct was actually prohibited. Under the Fifth Amendment's Due Process Clause, that's fatal. 9 justices agreed. Now, who actually benefits from this ruling? The numbers here are staggering. According to SAMHSA's most recent national survey, 64.2 million Americans aged 12 and older used marijuana in the past year. That's 22.3% of the country. More than 44 million are active monthly users. An estimated 17 million consume cannabis daily or near daily. About 1 in 3 American adults owns a firearm. Run those numbers together, and legal analysts estimate that somewhere between 43 and 62 million Americans were technically classified as federal felons under Section 922, G3, simply for using a substance that is now legal in 24 states and medically authorized in 40. Let that sink in. Up to 62 million people, stripped of a constitutional right, not for violence, not for a crime with a victim, for marijuana use. What changes practically right now? Federal and local law enforcement can no longer arrest, charge, or prosecute someone solely because they use marijuana and own a gun. The status-based prosecution is gone. Critically, police can no longer use the smell of marijuana alone as reasonable cause to believe a gun owner is committing a federal felony. That tool, frequently used as a pretext for broader searches, is constitutionally dead. Active federal prosecutions under this statute are expected to be dismissed. Courts are issuing what's called grant, vacate, and remand orders, unwinding pending Section 922, G3, cases in states like Maryland and Florida. And the ATF Form 4473, The federal form you fill out every time you buy a gun from a licensed dealer is already being revised. A draft published in May 2026 removes the automatic disqualification for medical marijuana users. Under Hemani, that revision is expected to accelerate. But before you think this ruling was some sweeping, unlimited Second Amendment expansion, you need to hear what the court was very careful to say it did not decide. Justice Gorsuch opened his opinion with a deliberate warning: this decision is narrow. Here's what the ruling does not touch. The government can still ban active drug addicts from possessing firearms. If someone is in the grip of addiction, not just a recreational user, but genuinely addicted, that's a different legal question the court left open. The government can still ban presently intoxicated individuals from possessing or using firearms. If you're high right now and you pick up a gun, that's still a valid area for regulation. The federal felon in possession ban under Section 922, G1, is completely untouched. If you've been convicted of a crime carrying more than 1 year in prison, you still cannot own a firearm. That law survived. Prosecutors can still go after individual drug users if they have specific, individualized proof that a particular person's drug use makes them genuinely dangerous. What they cannot do is skip that step and charge everyone based on status alone. And the court deliberately left open what happens with harder substances, methamphetamine, PCP, drugs where the argument that they always render users dangerous is stronger. Those challenges are coming. Congress is already responding. Legislative staff are drafting replacement language for the Gun Control Act, trying to replace the unconstitutionally vague unlawful user standard with something that can survive the Bruen test. And that points directly to why this ruling is just the beginning, not the end. Here's what most people are missing about Hemani. This wasn't just a marijuana case. It was a referendum on status-based disarmament, the government's ability to strip constitutional rights from entire categories of people without proving individual dangerousness. And that principle doesn't stop at marijuana users. Legal experts are already warning that Section 922, G1, the felon in possession ban, is next in line. Defense attorneys across the country are preparing arguments that nonviolent felons, people with decades-old, nonviolent financial or regulatory convictions, cannot be categorically banned from gun ownership without a founding-era analog that specifically targeted nonviolent offenders. The government defended Section 922, G3, by arguing it has broad authority to disarm anyone a legislature deems not responsible. The Supreme Court just said that standard isn't good enough. That reasoning now hangs over every other section of 922, G. The Bruen Doctrine has already generated nearly 3,000 federal challenges in 4 years. Hemani just added fuel to that fire. One unanimous Supreme Court decision, rooted in a case from a Dallas suburb about a man who smoked marijuana to sleep, and the entire architecture of federal gun law is now in motion. This video answered one big question: what the Supreme Court just took away from federal prosecutors. But here's the question this ruling opened up. What happens to the 20 million Americans convicted of nonviolent felonies, who still can't legally own a gun? Because the same legal logic that freed Ali Hemani today is already being aimed directly at the felon in possession ban. And that fight is going to be bigger, messier, and more politically explosive than anything you saw in this case. That video is up next, watch it now.